When can you sue someone for trademark infringement? This is the first thing you need to know right after you register your trademark. In this 20th episode of the Utsav Mukherjee IP and Tech Law Show, I am going to tell you about the grounds on which you can sue another party for infringing your trademark. I'll draw upon my personal experiences from handling trademark infringement matters before the Delhi High Court and district courts to make sure that you are well informed and aware of the legal rights in your registered trademarks. As the proprietor of a registered trademark of a brand, you and your team need to actively keep a check on competitors in your business that are using trademarks similar to yours to market or sell their own products or services. So, if you're using a mark which looks or sounds similar to your registered trademark, you have every right to take legal action against them, right? If they are using marks which look or sound similar to yours. So, let me break this down for you. Does the mark of your competitor consist of the same key elements as your trademark? Does it consist of the same word or words? Do they have a logo which is very similar to yours or with a similar shape, with a similar color combination or a similar font? Do they have a logo which, on the face of it, appears to be associated with your brand, right? Is there any phonetic similarity between the mark that they are using and your registered trademark? In simpler words, does their mark sound similar to yours? And most importantly, are they even in the same market as you for the same or allied products and services as your brand? Or is there any evidence that they are making attempts to enter into the same market as you? For example, if they've applied for a similar trademark before the trademarks registry. Now, if due to any one or a combination of these factors, an ordinary person of average intelligence on the first sight of the competitor's mark or on first hearing the name of the competitor's brand confuses it to be that of your registered trademark, then you can file a civil suit before a court for trademark infringement. So now that you know when to take legal action against a competitor, the question that probably comes to your mind is how to start this process. Well, first of all, I would suggest sending a cease and desist notice through a lawyer that specializes in trademark law to this party that is copying your mark. This is basically a legal notice sent through your lawyer informing this other party that if they are using a mark deceptively similar to registered trademark and if they don't stop this illegal usage, then you will file a case against them in court, right? And I've always recommended my clients to send this notice first before filing a civil suit. Unless, of course, there are specific reasons to take that party by surprise and get an immediate injunction against them from a court. Right? For example, if you want to have a court sanctioned raid conducted at the site of this party to seize and lock up large quantities of their products with the infringing marks, then you may want to file a case straight away and not warn them first with a legal notice. For those of you who don't know, an injunction is a stay order that you can get from the court, immediately restraining the infringer from using an infringing mark which is similar or nearly identical to your registered trademark. Now, even if you do get an injunction, the suit may go on till it is finally decided, unless the other party agrees to stop using the mark and comes to settle the case with you. Many a times they do come forward and settle the matter, leading to an early closure of the case. Otherwise, it makes sense to have first issued a cease and desist notice. This is for two reasons, right? The first is that at times, the infringer, which may be a smaller player as compared to your brand, may come forward and quietly settle the matter, thus saving you time, effort, and money that will be spent in filing a case against them and getting an injunction. And the second, even if you do go to court, at least you can show the court that you made an attempt to resolve the dispute amicably. And despite your best efforts, this other party either simply ignored your legal notice or in their reply refused to cooperate with you. This will make it even easier for you to get an injunction from the court, right? And on this basis, you can even avoid being sent to mediation by the court, as you can show the court that you've already tried to resolve the issue outside the court, but to no avail. And I myself have used this strategy recently in a case before the Delhi High Court, and I got an injunction from the court for my client, right? I showed the court that we sent a cease and desist notice, and even though we sent the cease and desist notice, they did not agree in their reply to cooperate with us, and so we came before the court for an injunction. Now, once you decide to file the civil suit, what all do you need to look into? First of all, you would need to decide which court you want to approach, right? Now, when it comes to choosing which court to file your case in, you have a couple of options. in no particular order of priority. The first option is the court within the jurisdiction of which the plaintiff resides or carries on business, right? And the second option is the court within the jurisdiction of which the defendant or the party against whom you are filing the case resides or carries on business. The third option is the court within the jurisdiction of which the cause of action has arisen, right? Any court within the jurisdiction of which the cause of action has arisen. And the cause of action here means the facts which have led to the filing of the case. So, for example, if the defendant's head office is in Chennai, yet one of its infringing products has been made available in Delhi, then you can file the suit in Delhi. And I always encourage clients to try and file their cases before the Delhi High Court if the jurisdiction is being made out, as they're far more likely to get an injunction from the Delhi High Court than from any other court in India. And I've personally experienced this in several cases, right? Now, the accessibility of a website within Delhi or the availability of pan India products and services are some such grounds on the basis of which you can avail the jurisdiction of the Delhi High Court by saying that the cause of action has arisen within the jurisdiction of this court. However, to approach the Delhi High Court, you will also need to show the court that the value of your trademarks is at least 2 crores. To support your valuation of 2 crores or more in your trademark, you will have to show the court the figures of sale and expenditure on promotion on your ads under your trademarks to show that you have, these high value trademarks. So now before I conclude today's episode, let me tell you about the fundamental issues that you need to satisfy the court about in trademark cases. You need to show the court that your trademark has been in use before, that is prior to the infringement, to the infringer, right? And this is even more important than the registration date of your trademark. Yes, in Indian law, prior use actually takes precedence over prior registration. And so you must put together various proofs of usage of your mark with dates, invoices, income tax returns, social media posts, newspaper ads, awards received, and the like, and file them along with your suit. So that was it for today's episode of the Utsav Mukherjee IP and Tech Law Show. Stay tuned for more exciting episodes on the intricacies of IP and tech law, and keep coming back to learn more about how to protect your brand value in your IP or to defend yourself in cases where you have been sued for violating someone else's trademark. Have a good day.